Hey guys, and welcome to another segment of ASK-VAL. We have Jamie, Gary with the White and Gary Law Firm here in Lake Charles, Louisiana. And we're going to talk a little bit about real estate and title, successions, donations, abstracts, all that good stuff. And real quick, Jamie, can you just kind of sum it up for us? Tell us a little bit about yourself. How'd you get started? What kind of got you excited about being an attorney?
Okay. Again, my name is Jamie Gary. I'm a lawyer at Dwight and Gary here in Lake Charles. Also member, manager, owner of Safeguard Title, which is an affiliate of Dwight and Gary. How do I get started as an attorney? It's an interesting question. Growing up, I didn't think it was never really crossed my mind I'd be a lawyer. But I went to undergrad with the intent to do marketing, advertising, have a marketing, advertising, journalism background, and some political science. So I think initially I was geared towards doing some kind of mixture between marketing and political science. And as I was about to graduate, a year from graduating, I decided, look, I think I'm going to just keep on going in school. I love to learn. And had a couple of friends of mine that were in law school, and so I decided to give it a try. So I got admitted to LSU Law School. It's a 3-year program, like most law schools. Graduated, worked for a judge for 1 year in Lafourche Parish in the town of Thibodeau, and after that, I started doing private practice. So in real estate, I have a general practice, and I've always maintained a general practice. But I've always done some title work. In the last 5 years, I've done a lot more residential real estate work, much more than in the past. A licensed insurance producer, which means is that I'm a title agent, insurance agent. I issue policies that cover insurance affecting property. Any given week, I may handle a litigation case. It could be a business, a personal case, it could be a property case, and I also sheriff's department too. But most of the time these days, I find myself reviewing abstracts, looking at a bunch of documents to determine who owns it, and whether there's any liens, judgments affecting the properties. And then I get to meet fabulous people like Val at the closing table and her clients and lenders. And it's a joy. I get to visit a lot of people in the community, and that's what I love most about it.
Yeah, because I would say, Jamie, I remember the first time I met you, I'm like, man, you're not like your typical attorney. You're so cool and laid back, and we enjoy working with you. So I think, Jamie, explain this to the audience, because we get this probably more than anything, and hopefully we find it sooner rather than later, because we're asking really good questions in the listing appointment, right? But talk to us a little bit about successions, because if you're in real estate, you know that either you ran across it or it's to come, where somebody has passed away and they left a property, and maybe they were married, maybe they were divorced, maybe they had kids. Can you speak to succession for our audience?
Sure. And succession is a word that we use in Louisiana law, and I think a lot of folks know that our Louisiana law is different than every other state in the country. We have a form of civil law that's different than the common law that's used in the other 49 states. So, and when you use the word succession, you can't just Google that up and find, that word across the country. So it's very unique to us. And so I bring that up because a lot of people, other states, and including Louisiana too, we throw the word out, probate. So probate is a form of a succession in Louisiana. And so the way I look at succession typically is it's a lawsuit that puts people into ownership of property they inherited. It could be through their parents, grandparents, siblings. It also could be pursuant to a will. And so from a title perspective, if you're on the seller side and you are the an heir of mom and dad that passed away. It could be last year, it could be the last 10 years, and nothing has been handled on behalf of their estate. As from a seller standpoint, you're going to need to get in there when you're ready to sell the property. Contact a lawyer to handle successions. There's plenty of folks around to handle this. Me and all of the firms in town to get started right off the bat, because there's going to be people. There may be judgments that were affecting mom and dad that passed away, and their names may affect the property. There may be a challenge to the will. There may be somebody's trying to locate the will. There may be a unique will in the sense that it might not be easy to prove in front of a court and get a court approval for that will. So there's just, as soon as you're interested in selling a property, you should start that process. We just find that a lot of these things are delayed by, particularly like the last couple of months, and that's no fault of anybody, but with COVID-19, the court system, there's a lot of delays, and that has postponed a lot of the closings lately. So, at the end of the day, succession is it's gonna clear title in the sense that it's gonna, if Val inherited a piece of property from mom and dad, it's gonna put the property into ownership of her name, so she can turn around and sell the property, or it may appoint Val as the representative of the succession and sell the property through the succession. So it never really goes out of the name of the mom and dad. It goes straight to your buyers. And that's the brief explanation of successions. And I'd say probably 7 out of 10 of our successions are really easy, and we can pump them through, and whether my firms handle the succession or a law firm in town, we can get it through pretty quickly and not slow down the closing process. But it's the 3 out of 10, I think, that everybody is wanting to close, and there's going to be delays if you don't start initially.
And what do you say is the biggest issue? Like when, say, mom and dad pass away, I come to you. What are the biggest problems that you know that a succession needs to be in place? And is it because maybe there's other kids involved? Not so much the liens and the judgments, but in the succession itself, what are the biggest issues you come across?
The first thing is there a will? And because if it's the will, if you're going to put people in ownership, whoever's entitled to the will, if you can put an ownership of them first before you turn around and sell it, the will is desire of your mom and dad at one time, and they went to probably a lawyer and have that drafted up, and so that's the most important thing. And then once you get that on the will side, once you get to the answers of, is it a valid will, number one, and number two, is somebody entitled to it, the property through the will, and then number three is get it probated at court. If there's no will, it's locating everybody that is an heir that is entitled to the property. And most of the time it's undivided interest. Let's say 5 kids and there's no will. So each kid presumably is going to get 1/5 interest each. You may have one kid that is in California, one in Georgia, one in Lake Charles, one in Shreveport, and another in Baton Rouge. It's easy to get signatures for the one in Lake Charles, but the ones across the other side of the state, and particularly out of state, that's difficult because, again, Louisiana law is different. We have to get this normally executed in front of a notary and 2 witnesses. And as of right now, we don't have any kind of e-notarization implemented in Louisiana. So out-of-state folks, they're used to doing everything online in particular states that allow that. And so they have to actually go find a notary, physically could find one. Most time get 2 witnesses while they're executing a notary, get that original, send it back to me by mail, preferably overnight mail, because we usually try to rush these things through. But we don't, in Louisiana, we don't accept any copies by email or fax. So I have the original back. That's number one. And number two is, again, going back to e-notarization. We just, legislation is not there yet to put e-notarization in place.
Gotcha. Yeah, I've actually had some of those instances. Yeah, well, it was something I was trying to pull up on my end, but I've actually had that experience where we go to sell and the spouse has passed away and the remaining spouse decides they want to sell, and then there's no will involved. And I remember one instance where it was like 12 individuals coming to the closing table, and there was a few of them that we didn't even know exist. So it was, to this day, it was probably one of my craziest closings. Outside of succession, Jamie, tell me about donations. Like, I think succession is one thing. Yeah, we understand that. But I've had incidents where the mom has given the son a donation. Nothing was really done as far as paperwork goes. So, can you speak to a little bit about donations as far as real estate goes?
Yeah. So in Louisiana, let's say mom and dad wants to donate some property to son. It has to be executed in front of a notary and two witnesses. So we're really, and that's just part of the formalities we have in a donation. So as a title lawyer, I'm looking at, is a witness by two witnesses, is it signed in front of a notary? Do you have a valid legal description that can show exactly where this property is at? Does that piece of property have access to a public road? And I bring that up because that's on two occasions recently I have donations where, for example, my dad owned 10-acre tract. They may donate a 2-acre tract to son. He wants to go build a house and on the 2 acres, and he needs financing to the bank. Well, the bank wants to make sure there's a title to it, and because the donation has no right of way within the act of donation, we have to go out there and actually get one. So we have to get mom and dad to another document mom and dad has to sign to get it right away. You could have all done that in one document. So I think it's really, I think when you're looking at donations, I understand, you're trying to get by with little money as possible, and and also you think this is family land, nobody's ever going to have any issues, but the son could be donated to the son, and the son passes away, and his will, he had everything going to his wife, and at some point that may be an issue with the neighbor and family members, and so the donation, it's not just simply, hey, I give this 2-acre property to me. It's got to have a good legal description, which I find most of the time it's not when it's not drafted by a lawyer, and there's no right of access, and again, sometimes not properly executed in witness. So I always recommend, look, go spend a little bit of extra money, get a title lawyer that knows what he or she's doing to draft act of donation, and set it up to a position where, because you truly are trying to help out a child and donate that, set up to where they're not spending money down the road to have clear title. And one other thing on that too is, I feel like some of these forms are found online. Again, Louisiana law is unique. So a lot of times people will find a form online, and it's not a Louisiana form, and so you're going to have some language in there that does not meet the formalities of Louisiana law. And even if it is a Louisiana form, you might have a cut and paste type deal where it's kind of put together by somebody just unfortunately doesn't understand what they're doing from a title perspective, and you just have an invalid document. And I hate to see somebody spend more money when they have to. It keeps me busy, but I know the intent is to help out. So
I had an incident where, if I recall it, it's been a while, where the mom donated the property, but she was married and the husband signed off on the donation. So do you ever come across those where?
Yeah, I had a little bit of delay. Go ahead and say it again.
No, I was saying that I had a few incidents where property was donated, but that individual was married, and it was never properly executed in the sense that the husband or the wife didn't sign off on the donation, but they donated it to one of the spouse's kids. That like recently happened, and it was a mess.
Okay, yeah. You and in Louisiana law, it's presumed if I'm donating to one of my kids, it is separate property. Different lawyers drafted these donations different ways. I think the safest bet is probably when you do the donation is to, if you really intend only to donate it to a child, have it to where in the document it says that it's for my child's separate property. But on an act of donation, you don't have to get the other spouse to acknowledge it's separate property, but you would have to on a document that transfers interest that's not a donation or gift. It's if I sell a piece of property rather than donate a piece of property to my child, but I want that child to obtain it as a separate property, his wife, his spouse has to sign off on a document acknowledging that it is his separate property. Particularly on a donation, it's presumed that it is to be separate property.
Gotcha. And I know you got a prompt over there with you too. So, and Jamie, I actually love these because I love history, right? Speak to what is this? This is good old Louisiana for you, right? History. So I love to look back at the origination of a property. But speak to these. Speak to this is an abstract. What is that exactly? Why don't we use them anymore?
Yeah. So first of all, they're very interesting. I love them. And an abstract is a set of documents that contain all documents that pertain to a piece of property that you find at the house. So these abstract books that you showed us, and I have, until recently, that's what everybody used when it comes to abstracts. Typically, those abstracts go back to the 1800s. In Louisiana, depending on what part of Louisiana, it could go from the U.S. government to Louisiana government and then to an individual. It could go straight from the U.S. government to an individual. You even see some Spanish grants in some abstracts in certain part of Louisiana too, which is very interesting. But those books, we still use them today if a seller brings them to me, and I review those, but I only review them up to the last date that they're searched for. So on the abstract book that you showed, like these books right here, what it is it'll start off with the initial conveyance from the government to an individual and go through a certain date, okay? And so let's say the abstract goes to today. That is from the time the government sold it to individual up until the current date, and it's every document pertaining to that property, including transfers of the property interests, right-of-ways that may affect the property, mortgages, judgments, liens, oil and gas leases, a number of things. So anything that could affect the property. But these abstracts, typically, I know my office, we don't order those anymore, the booked abstracts. And I think that's generally most title companies and law firms don't do it anymore. I think it's mainly to do with the cost. We're asked to try to keep the cost down as much as possible, mainly for finance reasons. And we like to do that. So what I do is either I hire what's an abstractor. Abstractor is the person that goes and pulls the documents out of the courthouse, just like they would do for these books that we showed. But these days they pull those documents for me and they fax them to me or email them to me. And I review those documents. So it's the same thing as if having a book, but what they do is they go back. I usually order a certain time period, not going back to the 1800s, and I review those documents. But those books are great. Their books are great in the sense that, every time a piece of property is sold, if you have those books, normally the new buyer gets those books at the closing. That's not mandated by law or anything, but it's a typical practice. And
right.
I always ask, what I fail to ask and get ahead of a lot of times, I think this is my fault, is that, the seller may have an abstract on these books, and they could, by providing those abstract books to me, and right when a house goes into contract, it would probably speed up the process, because I could take a look at that book and get a good feel for what's going on, if there's any kind of title issues, update the title, which means is that if that abstract book went from 1860 to 1982, all I have to do is for the new abstract is run it from 1982 to 2020.
Right. Exactly.
So, and it may save time and money for everybody. So, and a lot of times at closing, the sellers will show up with the abstracts, and I give it to the buyers. But in my mind, I'm like, why didn't I ask those people before? When they went under contract for abstracts, and that's it's hard to say, how do you get ahead of that? And because we're all moving so fast on these deals, particularly lately. So it's something in the future I want to try to work on and get more involved with agents and getting those abstracts ahead of time. So, but they're very interesting. I find buyers, or sellers, when they show up, they said, and they'll hand the books to the buyers, and they're like, you need to go look at this page. They traded horses, there's unique parts of this property and unique individuals along the way. But it's interesting to read. So
yeah, talk about a complete history of the property. So, and again, just to kind of reiterate, and that's a nugget for me too, because I typically don't ask for an abstract during our listing appointment. And that's something that, Jamie, I'm going to make a commitment to doing, because especially right now, like you mentioned, with COVID, like most files are being pushed back. So if you guys are listening, for our sellers, if you have this book at home, it's your abstract, if you're not sure what it is, as soon as you're thinking about selling or you get something under contract, deliver this to your title company, preferably to White and Gary. Anything else, Jamie, you want to kind of touch on, like you see as far as real estate goes, industry-wise, anything local, anything else that you can think of that maybe the audience does or maybe needs to kind of get a refresh on?
Stay in communication with your agent, your bank, and whoever's handling the closing. We live in a world with a lot of emails. Everything's online. I think it's great communication. It allows us the ability to give our thoughts at any given moment. It could be night, whatever it may be, and also send the documents along with it. But I find sometimes there's not enough actually picking up the phone and calling somebody if there's a question, that it's just sometimes pick up the phone is more easily resolved by issues are resolved, but easily by picking up the phone. So now, granted, I don't think any of us want a phone call, a bunch all day long, because then you're putting off every single title request that you're working on. That there's a lot of questions that could be answered by email, but I think that sometimes it's just, I've found myself guilty of sometimes, I rely too much on email. And then, look, some people might feel totally different about it, but I think that's at the end of the day, as long as we have line of communications open up, I think everything goes much smoother. I did think about this yesterday in preparing for this video. I think when I pick up the phone, I call somebody. The caller ID says a law firm on there, and I'm calling to somebody that's either selling or buying a piece of property. And sometimes it scares them. A lawyer's calling, and I think they see they don't come to lawyers law offices that often, which is probably a good thing. But so
Right.
I think they get scared of it, and all they see on TV is lawyers from an adversarial standpoint, whether it's a civil litigation or criminal litigation. More likely than not, a criminal, TV shows have, Law and Order, stuff like that. You're looking at lawyers, the public generally looks as an adversarial perspective. But as you know, in our world, is that we're trying to get the closing done. So, the sooner we close, the better for everybody. And, sometimes I find that, in picking up the phone call or sending an email, like these are the title issues, and particularly reaching out to sellers. And I don't really like issues, because at the end of the day is that I'm not charging any extra based upon any kind of title issues. We just want to get it done so that the new buyers have no problems at all, or as few problems at all. There's no guarantee in anything in life, but so we get it right or try to get it now. And so it's not coming from an adversarial standpoint. It's just, we're trying to get it right. And I do think some people are kind of skittish about that, or think that by having issues, we're just driving up the costs. And I think it's a misperception. I hopefully in picking up that phone or sending me an email, hopefully I, clear that issue up with I don't want to have those issues, but they're out there. So let's get them fixed now.
Yeah, and just to kind of touch on what you said about communication, you guys do an amazing job. Mary is absolutely amazing at your office as far as making sure things are in line. She communicates well. Your office communicates well. And we absolutely love and adore you. Jamie, why don't you tell folks where you guys are located, how they can reach you if they have any concerns or questions or need to open up title? How do they reach you?
Yeah, so the best way, if you're an agent, lender, and you get the title request, send to my office by email. It's like you said, Mary's great. I can't say enough about her. That title request should go to her. She'll put it in line to start the process. Her email's mary@dwightlaw.com. Of course, we have, you can pick up the phone and call us, and then we could give you email over that, or give some other way to get the process started. Where are we located? That's a really interesting question right now. So, we're located downtown Lake Charles, but our sign to our building got destroyed by a storm a month ago. It was a brick sign and brick columns, and it has been really hard to find a bricklayer that can come out here and fix our sign. So the last several weeks, I have had a lot of people call or show up and say, I've been looking for your building for 10 or 15 minutes now. And so we are getting something temporary put up, but we are located between Home Furniture and ICCS, the private Catholic school, or as me and other people, older generations referred to as the old, I think it was the Borden's Dairy. So
yeah,
so we're just a couple buildings down from Furniture.
And what's your phone number, Jamie? Directly, what's the phone number to the office?
Yes, 337-439-3138.
Got it. Well, guys, that is Jamie Gary with Dwight and Gary Law Firm, Safeguard Title here in Lake Charles, Louisiana. Jamie, we absolutely appreciate you for being on with us. If you guys have any questions, again, we will be posting Jamie's information in a direct link to their email and their address and phone number as well. Thank you guys for listening and joining in. And again, Jamie, thank you so much. You guys have a great rest of your day. Hope you're all staying safe healthy. Until next time, we'll talk to you guys soon. Bye, Jamie.
All right. Thanks for having me.